I want to talk on one very narrow topic, and that's blocking orders which the courts grant. Blocking orders to prevent websites that deal in infringing materials from continuing. In the copyright area, various countries have implemented legislation which empowers the courts to grant these orders, requiring internet service providers to block access to websites infringing or facilitating the infringement of copyright. Singapore has such legislation in place. However, in the case of trademarks, that is websites that deal in counterfeit goods, there is no equivalent legislation in place. However, the English courts have granted blocking orders requiring internet service providers to block access to websites selling goods bearing counterfeit trademarks. And the English courts have done so, although there is no specific legislation dealing with such matters. One such case, which I can make reference to, is Cartier International AG versus British Telecommunications PLC. This case went all the way to the Supreme Court. The High Court and the Court of Appeal adopted jurisdiction on a number of different grounds. But when the case reached the Supreme Court relied on all established principles, and it made two important observations. First, that in equity, once an intermediary has been given notice of an infringement of the plaintiff's rights, the duty of the intermediary is to stop placing his facilities at the disposal of the wrongdoer. Second, the ordinary principles of equity empower the court to make website blocking orders, as such orders are in the nature of an order which a court may make against a third party to prevent the use of its facilities to commit or facilitate a wrong. These sort of facts have not arisen in Singapore, but what I can say is that these English cases will be highly persuasive if a similar fact situation does arise in Singapore. So it's, to my mind, a satisfactory way of dealing with online violations. And in fact, on this note, I would ask Michael a question insofar as the Canadian case is concerned, because although the Canadian case, the Canadian courts came up with a solution, but that solution was to a large extent nullified when Google went to the American courts. So my question really is a question that the dissenting judges raised in that case. Why did the Canadian plaintiff not seek such an order to go against the internet service providers?
Well, I'll go backwards for a little bit. First of all, blocking orders. In Canada, there was a case back in 2019, Bell Media and Gold TV, which on appeal was Tech Savvy and Bell Media. And a blocking injunction was granted there to targeted IP addresses. The problem with it was slow, it was cumbersome. It had to be specific in terms of what would be blocked. More recently, in a Rogers Media John Doe case, which was 2022, the federal court issued an injunction directing Canadian ISPs to block access to certain IP addresses identified in real time during NHL hockey games. It was limited to the season, but it was a dynamic blocking injunction as opposed to a specific identification of IP addresses. So we're evolving. I think the comment made earlier that the law lags behind technology is absolutely true. That being said, the courts are trying to deal with more flexible approaches to how do we deal with, and the Equistack case that you're talking about in the Supreme Court of Canada, where they issued an international injunction against Google. And the California court said, yeah, no, we don't really care what the Canadian Supreme Court said. We're not going to follow it. Territoriality trumps anything a foreign court may do. So again, you're seeing the conflict of interests mostly based on territoriality and domestic rights trumping even treaty rights. I was talking with Iris earlier about that. So we've got a lot of problems in terms of the lack of harmonization, in terms of enforcement. I mean, it's one thing to say, you know, you've got rights. Will a court will exercise those rights beyond the borders of one of our countries, but then how are you going to enforce it? And that's been the problem from the get-go with the internet. It continues to be a problem today. And I think the real issues for courts and lawyers is even if you have a court willing to do extraterritorial relief or to deal with blocking orders or injunctions with ISPs, how are you going to enforce it? And I think, I mean, I don't have an answer. I don't think our court has an answer because, as was said earlier, we're still trying to evolve on how we can do it. I think, again, we've had this discussion in previous talks. You know, it's bilateral and multilateral treaties seem to be, and trade related treaties seem to be one way that we can actually get better enforcement on an international basis. But absent those treaties, it's going to be very difficult to get beyond the territoriality problems that we're facing.
I have a slight experience to share. I was a judge on the IPR side a few years ago, sitting singly, and a large number of content providers, that's the film makers, including 20th Century Fox, Sony TV, Sony Pictures, and UTV. The judgment goes by the name of UTV. Approached me saying that their films were being pirated and being released. Unlike Singapore, we do not have any codified law with regard to injunctions to be passed with regard to pirated films. And the issue was that they were saying that the infringer, if you block his site, he just appears on a different site. For instance, you block torrent, he'll appear as torrent 1 or torrent A. These are called the alphanumeric sites, or they resurface as redirected mirror sites, as they call it. So we passed a dynamic injunction order, which Michael was also referring, which was directed against the internet service providers or internet intermediaries, as we call them in India. And by this blocking process, we said that not only will they block the site which has been injuncted, but also those alphanumeric sites which crop up immediately. And this we called dealing with the concept of Hydra-headed rogue websites. And we ensured that they do not surface. Today, virtually every weekend, at least 2 fresh suits are filed on the intellectual property side. Whenever a new film is being released, that please pass a blocking order. And this blocking order has not been 100% successful, but successful to a very, very large extent. So that's been a very positive experience that we have had in India. And this dynamic injunction has held the field. It's something concept which has got established in India for the last 2 years, because I think I passed the judgment in 2019 and today we are in 2023. So it's worked. It's holding the field as far as that is concerned.